What is a will? A will is a document where you get to say who gets what and who is in charge of making that happen. Someone named in a will to receive your assets is called an heir or beneficiary. And the person put in charge of making that happen is called a personal representative or an executor. It's important to note, though, that wills do not apply to assets where you have a surviving joint owner of that asset or to assets where you have a living beneficiary designated. For example, on retirement accounts and life insurance, if you have a spouse named and then maybe your children, then that asset will be payable directly to the living beneficiary whose name is separate from that a will says. If you have a will, and a will is really critical for your estate plan, you need to make sure that it's in sync with everything jointly owned and also everything where you have a designated beneficiary to make sure it's all working together according to your wishes. Also, for any property passing under the will, it's important to note that the will has to be filed with the probate court and reviewed and approved before anyone named in the will, the personal representative, can act on your behalf. They will gather your assets, pay any creditors who might be owed money, and then ultimately distribute the assets to your heirs. A will is a document that does have to go through probate, which is actually a common myth that we run across. People think that a will is a magical document that covers every estate planning scenario, but it doesn't. It's critical and you need it, but you need to make sure that you understand that it goes through probate before it is effective. And that is a will.